and you are very welcome. This is The Beautiful Truth with Fintan Dunn reporting. Thanks for joining me. Good to have you here for this good news. Not so good news for the Irish government, which suffered a defeat in the upper house on the adoption bill, which was defeated 21 votes to 18 as a result of Senator Lynn Ruane, with the help of Senator Francis Black, proposing an amendment to that bill, which otherwise would have gone through unchallenged in its existing form. Now we have the potential for a new look at that bill before it comes into law. Why is that? Well, this campaign was urging that we exercise care because the High Court under this new law will be able to dispense with the consent of parents when making an adoption order for their children. So that's a serious matter, and it's the sort of thing that you really should handle with a great deal of discretion and care in case you cause serious injustice. As a result of that danger, these lines here were inserted in the amendment, which was passed by the Senate, so that if the Child and Family Agency is satisfied that every reasonable effort has been made to support the parents of the child to whom the declaration applies, then the adoption may proceed. But it makes it all contingent on the every reasonable effort being made to support the existing parents of the child and not construct a system which could, turn into a steamroller or a roller coaster into adoption. That's an issue which was touched upon last year by Cathy McMahon, who spoke to the Irish Parliament on issues around adoption arising out of essentially forced adoptions. So it shows that we can, on a mass scale in mother and baby homes, violate the rights of people, and so it's contingent on us to take special care. As a result of that, we have to look at how adoptions such as this would arise, and of course they'd arise through the family courts at first, issuing care orders and then fostering arrangements perhaps been made, etc. But there are dangers if the system, which is in place as a result of the children's referendum, which was passed in Ireland, giving cognizance to the rights and needs of children in the legal system, which is a benefit, of course. But what if the rights of parents are not been properly vindicated? The Childcare Law Reporting Project, which has a mission to examine and report on childcare cases in the Irish state, as a result of research presented with, in 2015, at an international conference on child protection and the law, clear evidence that we perhaps aren't living up to what we think is going on in family courts. The proceedings were opened by a former Irish Supreme Court judge, Catherine McGuinness, and let's just listen to her opening remarks in part.
We now have that wide-ranging account of what is actually happening in courts, both in Dublin and across the country. And as the title of this conference indicates now, the stage has been reached for an in-depth consideration of what we have learnt from the information gleaned by the Childcare Law Reporting Project.
So that's the challenge, and that's back in 2015. Well, let's get on to the detail of what actually was presented to the conference, and here's in particular an important presentation by Dr. Conor O'Mahony of UCC about parental representation and their participation in the proceedings of the courts in Ireland. And I'd like you to have a listen to the kind of conclusions he came to and presented to that conference. Let me give you full volume on this.
That there is a gap between the theory and reality. The theory of the Child Care Act and the Constitution and the international conventions are that parents have very, very strong rights, and that there's a whole host of mechanisms designed to protect those rights in practice. In reality, we see that the real picture on the ground is that there may be potentially some gaps between that theory and the reality. The process is supposed to be weighted or tilted in favour of parents in the family, and yet we see orders being granted at very, very high rates in some areas. We see that legal representation is in theory available, but yet we see orders being made at an interim level in quite a few cases without legal representation being present. We see, even where legal representation is present, we see that it is delivered under conditions which make it very challenging for the representatives in question. And we see that while parents have a constitutional right to fair procedures and to all these fancy principles like audi alteram partem and everything else, which implies that they should really be able to get in there and present their side of the case, in reality we have parents who perhaps feel unable to speak up or perhaps don't fully understand what's happening.
So there you are. That is as a result of a pilot study which was conducted and other research by the Childcare Law Reporting Project. And of course none of this is to be in any way condemnatory of the professionals who are involved in this area. Truth is, all of this is extremely difficult and every case is in fact unique. Let's listen to Dr. Carol Coulter.
It's essential that parents in child protection proceedings have access to qualified and experienced experts who can, if necessary, challenge the expert evidence put forward on the part of the state.
Now that's a key and vital aspect of the legal system. If you can't afford to come up with the kind of resources and expert testimony which the Irish state can, and you're trying to defend your right to be the parent of your child, and perhaps you're already encountering difficulties which maybe the state itself has helped create by abandoning you to homelessness, for example, well then you need the best possible legal representation in order for us to have an effective system. What else do you need? Let's listen to Dr. Conor O'Mahony make further recommendation.
But we would share certainly Carol's recommendation around the need for specialist family courts to deliver a greater level of consistency, to deliver better facilities. Physical facilities was a huge part of our research. That if you talk about lawyers representing parents, for example, if they're consulting with the parent on the side of a street or in a busy corridor, that makes the consultation far less than ideal for both the lawyer and the client.
So, we must be absolutely sure we're doing it all right, and a family court system where we get a little bit more consistency in the way judges deal with these matters is an essential component of all of this. It's also important, as Dr. Coulter addressed in another speech she gave, that in Ireland, under the Constitution and European law, which we have ratified, these both emphasise the right of a child to be brought up in his or her own family, stressing that interference with that right is a last resort and that reunification of the family must be an ongoing aspiration. And this is indeed supported by judgments of the European courts. So it's important that we get this right as well, that we don't construct an entire system which operates against parents' interests and doesn't keep families together. So those are the issues which have come up. We have an amendment proposed here which would address this, and I hope parliamentarians will support that in the Irish Parliament when the Senate sends it back for further consideration by the lower house. And I hope that you also will encourage your representatives to take this kind of action and support this, and support what Lynn has done and Frances has done. And I'd like to thank her and Rob, Seb, the rest of the team for terrific work, and it's great that we are addressing this. I think this is a welcome defeat for the government, and perhaps will help put a spotlight on making sure that we have an effective system in place to deal with all of these issues. Okay, you'll find more at motherandchildreunion.org, and you can also look for the Abduction Rights Alliance on Facebook. This has been Fintan Dunn reporting.